This is Melissa Negrin-Wiener, Elder Law and Estate Planning Attorney with Genzer, Dubow, Genzer & Kona, and this is Elder Law Matters. Today I want to talk to you a bit about why you need an elder law attorney and what elder law is. Elder law and estate planning are two very different things. Estate planning deals with powers of attorney and healthcare proxies, living wills, trusts, asset preservation, estate planning, things like that. Elder law is more of the Medicaid applications, home care, community Medicaid, institutional Medicaid in a nursing home, how to protect as much as you can as far as your assets go while applying and qualifying for Medicaid. So why does a person need an elder law attorney to do these things? Over the past few years, a trend has begun where people are going to Medicaid specialists or Medicaid advisors who are not elder law attorneys. This type of choice can be extremely costly. We have seen so many different things happen when clients come in to see us who have originally gone to see a Medicaid advisor or a Medicaid specialist that we have to turn around. For example, I wanted to talk specifically about the caretaker child exemption for Medicaid purposes. The caretaker child exemption is a special exemption that says that if you have a child living with you for at least 2 years prior to your need for a nursing home, the house that you're living in can be transferred to that child with absolutely no Medicaid penalty. The thought being that that child has helped to keep you home for the last 2 years by being a caretaker child. In order to qualify for this exemption, we have to show Medicaid that you are indeed a child, so we'll show them a birth certificate, and also that you have been living in that home, that's your primary residence, for at least the past 2 years. And we can do that, typically we do that with a tax return, the first page of the tax return for the last 2 years, showing that that's your primary address. Or we can do it with other bills or driver's license, things like that. So those are the two things that need to be proven to the Department of Social Services to show that you're a caretaker child. So first I want to start with a woman named Susan. Susan lived with her mother for 30 years in the home that she grew up in. Her mother became ill and her mother needed to go to a nursing home. There were really no other assets to speak of, so Susan went to a Medicaid specialist that she had been referred to apply for Medicaid benefits for her mother to go into a nursing home. The Medicaid specialist did advise Susan that the house would be protected as long as Susan had been living there for at least 2 years, which she had. As I said, she lived there for 30 years, and she grew up in that house. So Susan went on her way with this Medicaid specialist to go ahead and apply for Medicaid benefits, and they were approved. Her mom received Medicaid benefits in a nursing home. She was there for quite some time, and then her mother passed away. This is when we heard from Susan. She received something in the mail from the state, basically asking her for $225,000 from her mother's estate. Now, why would her mother have an estate if she was on Medicaid? Well, she had an estate because the house was still in her name. When you pass away with a house in your name, you have to bring an estate proceeding to make sure that that house passes according to your will or the rules of intestacy if you don't have a will. Okay? Medicaid had a claim against mom's estate because Medicaid had paid out approximately $225,000 on mom's behalf. But why? Okay, well, first, let's look at this. You can qualify for Medicaid, and I've said this before, with a home in your name. Okay, so you can keep your home as long as it's under a certain amount of money. It's about $850,000. You can keep your home and qualify for Medicaid, but Medicaid is going to put a lien on that home. So when Susan went to the Medicaid specialist and they advised her, sure, the house can be protected as long as you've been there for at least 2 years, they left out one very important piece of information. The house needs to be transferred to Susan. Had the house been transferred to Susan, the house would have been completely protected. There would have been no claim, there would have been no estate, and there would have been no claim against the property. So in a case like this, we have to try to explain to the Department of Social Services what actually happened to see if we could get that lien lifted, or have them pull back the letter asking for the $225,000 and allowing the property to go to Susan. You have to remember, here in a case like this, Susan was planning to live in that house for the rest of her life. That was her home. She had no other home. She had nowhere else to go. So we were able to, through hearings and through a lot of negotiation, protect that home for Susan. However, the money that Susan and her mother saved by going to this Medicaid specialist to do the application cost her plenty more to go through all of this process at the end, and the emotional piece of knowing that she could potentially lose her home. So it's the old adage, you get what you pay for. And I know it sounds cliche, but more and more people are jumping on this Medicaid advisor or Medicaid specialist job, and it's just, we're seeing problem after problem. They're very costly mistakes. This is Melissa Negrin-Weiner, elder law and estate planning attorney with Genzer, Dubau, Genzer & Kona, and you're listening to Elder Law Matters. And we're focusing today on costly mistakes that are made by not going to an elder law attorney. The laws related to, especially to Medicaid and Medicaid planning, are so intricate that if you're not immersed in the rules and in the process every single day, there's going to be things that you miss. There's going to be little nuances, little things that are missed, and it could end up costing a client a lot of money. So we ask people to really look into what you're doing and who you're doing it with. Caretaker child, for example, is only one special exemption. There are others. There's a disabled child exemption. The disabled child exemption says that you can transfer everything that you have to a child who has a disability. Now, that child should be able to show that they're receiving Social Security disability, and all of the assets can be transferred to that one child. But it doesn't just stop there. That child could be on Medicaid themselves or some other government benefit that says they can't have more than a certain amount of money in their name. And now all of a sudden, mom is being told, transfer everything to your child who has a disability and we can get you on Medicaid with no problem. Well, what happens once that child comes into all of that money or that home? Suddenly, they no longer qualify for their benefits. Okay? Another way to do it, of course, is to transfer the assets to a supplemental needs trust for that child. But by doing that, you are limiting whatever you're passing along to your family to that one child. So if you have other children, those other children typically are not going to see any of those assets unless something happens to the child who's disabled, and those other children are the beneficiaries of their supplemental needs trust. So there are so many levels of concern and so many things you need to look at when you're dealing with these small nuances, these intricate details of Medicaid planning and Medicaid applications. And that's why it's so important to make sure that you're working with somebody who knows exactly what they're doing, who can come up with the best plan for you and for your family, and who's going to make sure that nobody down the line suffers because of a mistake that was made or a suggestion that was made that perhaps wasn't the most educated suggestion. Another exempt transfer for Medicaid purposes is a spousal transfer. You can transfer everything to your spouse and apply for Medicaid in a nursing home. There are a lot of concerns that go along with that as well. The spouse needs to make sure they change their will. Their will most likely leaves everything to their spouse who's in the nursing home. So if the spouse at home passes away before the spouse in the nursing home, which has happened and happens often, then everything that we've transferred to the quote-unquote well spouse is now going to go back to the spouse who's receiving Medicaid benefits. So you have to make sure that you follow through the plan. And it's become very obvious to the elder law bar that a lot of people who are becoming these Medicaid advisors and Medicaid specialists aren't going through the process of making sure that everything is carried through the way it needs to be. And of course not, because they're not practicing law. So this has become a big issue, and it has cost clients a lot of money. This is Melissa Negrin-Weiner, elder law and estate planning attorney with Genzer, Dubow, Genzer & Kona, and you're listening to Elder Law Matters. We're going to take a commercial break, and we'll be back shortly. Welcome back. This is Melissa Negrin-Weiner, elder law and estate planning attorney with Genzer, Dubow, Genzer & Kona, and you're listening to Elder Law Matters. Before the break, we were talking about costly mistakes and why people need to seek the assistance of an elder law attorney when they're working towards applying for Medicaid or asset protection planning for Medicaid purposes. And we were talking about the trend in people going to see elder care specialists or Medicaid specialists to take care of Medicaid applications for them because it's less expensive than seeing an elder law attorney. And over time, we've begun to see as an elder law bar a lot of mistakes being made, and the mistakes can cost clients a lot of money. We were talking about the example of a caretaker child before the break of a woman named Susan whose mother went into a nursing home. Susan had been living with her for 30 years, and the elder care or Medicaid specialist that they went to advised the family that as long as Susan was living in the home for at least 2 years, the house was going to be protected. Now, that's kind of true. The real regulation says that the home can be transferred to a child who's been living there for at least 2 years prior to the admission to a nursing home for the parent, without any Medicaid penalty. But what happened in Susan's case is they were never advised to actually transfer the property. So even though Susan's mother was approved for Medicaid, because you can be approved for Medicaid with a home in your name, when Susan's mother passed away, she got a letter from Medicaid, from the state, asking for $225,000 from Mom's estate, which consisted of Mom's home, because that was in her name when she died. So because that house wasn't transferred to Susan, which was an exempt transfer for Medicaid benefits, for Medicaid purposes, Susan had to then deal with not only the passing of her mother, but the frightening possibility that she may have to sell the home that she planned to live in for the rest of her life and turn most of the money over to Medicaid for care that was given to her mother. So these types of mistakes can end up costing clients a lot more money than it would have cost them to see an elder law attorney in the beginning and have things done correctly. Another example of this was a married couple by the name of Paul and Shannon. And Paul and Shannon lived with Paul's mother for a few years. They had their own home. They had to sell it and move in with Mom for some financial reasons. And so they were living with her for a few years, and then she needed to go to a nursing home. Now, once again, Paul and Shannon went to see a Medicaid specialist. A Medicaid advisor, I believe, was the term that she used. And they were also advised of the caretaker child exemption. And this particular advisor knew that the house needed to be transferred. So she transferred the house, or they went to have the house transferred to Paul and Shannon, and Mom went into the nursing home. Now, in this case, Paul and Shannon got a notice from the Department of Social Services that said, your mother is approved for Medicaid benefits, but she's not eligible for the next 40 months. So you have to pay privately. They had no idea what they were looking at. What turns out happened in this matter is that the transfer of the property to Paul and his wife completely got rid of the caretaker child exemption, because the caretaker child exemption is specific to the child, not an in-law, not a niece, not a nephew, not a grandchild. It must be a child. So Paul was the caretaker child. If the house would have been transferred to just Paul, we would have had no issue at all. But because the house was transferred to Paul and Shannon, there was no caretaker child exemption at all. But somebody, again, who is not immersed in the intricate details of Medicaid planning and Medicaid applications could miss something like this. So what was the result? The result was either Paul had to figure out a way to pay for 40 months of nursing home care before Medicaid would pick up to the tune of approximately $10,000 to $15,000 a month, or Paul had to seek counsel to try to fix this problem. And fixing this problem involves going to a hearing, spending hours of time preparing, hours of time at the hearing, and then hoping that you can be successful. And in this type of case, we had to show that if the property had been transferred to just Paul, we would not have had an issue, and basically hoping that that would allow us to do that in after the fact. So these are just two examples of the types of things that go on when people who are not properly trained and, again, immersed in the day-to-day changes of these types of Medicaid regulations are working in this regard, are practicing in this area. There are so many other examples of exempt transfers that I was mentioning before the break, like the disabled child exemption. So that says that you can transfer all of your assets to a child with a disability, and then you can qualify for Medicaid. But as an attorney, as an elder law attorney, we know that we need to check every level of planning. We need to check the planning and how it affects every person down the line. So we know to look at the disabled child and say, okay, is this child receiving a government benefit that they're going to lose if mom or dad transfers all of their assets to him or her? You can't just make a transfer not looking into the entire situation. So in a case like that, where maybe perhaps the child is on Medicaid themselves, we can't take advantage of that exemption. We can't transfer the assets to a child with a disability in that case, because we're going to negatively affect that child. So are there other ways to do it? Absolutely. And might those ways result in not being able to take advantage of an exemption? Absolutely. But doing it wrong can end up costing the family so much grief and so much money at the end that it's just so terribly important to make sure that you're dealing with somebody who knows how to handle these types of situations. Let's look at the Medicaid application itself. The Medicaid application itself, for nursing home purposes, is a 5-year review of bank records. And in that 5-year review, we have to explain to Medicaid all transactions that exceed approximately $2,000. So $2,000 or more going in or going out. Where did it go? What was it for? We know from working all of these years with the Department of Social Services and the different caseworkers what we have to explain, how we have to explain it, what we need to document. People who are not trained and immersed in this area, these Medicaid specialists or Medicaid advisors, are not trained and do not have the experience necessary to know what's going to be accepted, what's not going to be accepted, and how to deal with the problems before they become real problems, before they become expensive problems. So the real takeaway from today's show is, again, the old adage, you get what you pay for, that couldn't be true enough in this type of situation. I've seen people like Susan and couples like Paul and Shannon month after month after month come into my office with problems, things that did not go well. And we could have avoided all of those problems had we been able to deal with the Medicaid application or the Medicaid planning from the beginning. So it's an urgent message to be sure that you see somebody who specializes and who knows exactly how these laws work, how they change from day to day, month to month, county to county, and just to stick with somebody who knows the area, who's not just a Medicaid specialist or Medicaid advisor. This is Melissa Negrin-Weiner, elder law and estate planning attorney with Genzer, Dubow, Genzer, and Kona, and this is Elder Law Matters. I'm here every Sunday from 4:30 to 5 o'clock talking to you about all different aspects of elder law and estate planning, of asset protection, Medicaid, Medicaid home care, Medicaid in a nursing home, trusts, wills, and also advanced directives, power of attorney, healthcare proxy, living will. We'll cover all of these topics, how they intertwine with different areas of law, like divorce or bankruptcy, and we will go into each topic and explain how every single one works. This is Elder Law Matters.